Good morning. My name's Maurice Crespi. I'm the managing partner of Schindler's Attorneys, co-founder of COBRA, together with the IQ Business and Engaged Business Turnaround. I'm joined today with a panel, Ian Fleming, the CEO of Engaged Business Turnaround, Peter Gordon, Engaged, Emma from IQ Business, Paul Michael Keichel, he's a partner of mine at Schindler's Attorneys, Artisha, from IQ Business, Dominique Lloyd from Schindler's, Dean Wright from Schindler's, and Gary Baruchowitz from Schindler's. So we've got quite a panel here today. If you have any questions, the idea today is that you ask questions so that our panel can jump in and answer those questions. We have a broad range of expertise here today, from labor to the various funds to business rescue, to legal aspects. So to make this worthwhile, I ask that you post questions, because that's really the point of a webinar. It could be quite easy for us to simply record and replay it on a daily basis as a video. So we ask that you provide us with questions. Yesterday we had a great session because we had a whole host of questions that makes it far, far more exciting. So if you can ask questions, the questions are they can be specific to your industry, they can be specific to your business. Just let us know. If you feel that your questions are inappropriate because they're possibly too specific, COBRA is a pro bono service. We have pro bono meetings with business owners, with the staff if need be. We can consult with the staff if need be, or meet with your team and to address specific questions. This is a time of high anxiety, and we are prepared to assist wherever we can. And if it requires 5 Zoom meetings a week to address issues that you're faced with, well, that's what we're there for. That's what COBRA is about. Let's just explain a bit about COBRA. You're going to hear about business rescue today, and much of the discussion is going to relate to business rescue. Business rescue, in the context of COVID-19, is a very, very different creature. Most companies are financially distressed, so most companies find that they are getting pressure, they're receiving pressure from their creditors, but in turn, those creditors are also applying pressure. So everybody understands and appreciates the situation, but no one is quite aware as to, or doesn't quite know what to do in these circumstances. So COBRA, we avoid business rescue at all costs. The idea is you enter the COBRA ecosystem, and we engage with your creditors to invite them into the ecosystem, to have us deal with your creditors, and to strike arrangements right up a supply chain. So right from the bottom all the way up, all the way to the bank. And the idea is, we've got banks who are about to onboard. We have a whole host. We've got 24 partners at the moment with a whole host of applications. The idea is that every partner who jumps on board has pledged to provide pro bono assistance to any business, from a spaza shop all the way up to a listed company. And the professional teams to deal with, let's say, the listed companies, that would be IQ Business, then and Engaged, and then we have specialists in even the spaza shop environment. In fact, we've got an entire division that's been created to help out at that level. So, not about business rescue. We're going to talk business rescue. Business rescue is only going to be implemented if there's a commercial reason, and we'll take you through the commercial reasons, or if a creditor is being unreasonable. A creditor being unreasonable means that the creditor is applying pressure. Why does a creditor apply pressure? To increase his or her bargaining position. That's why they apply pressure. So the moment you put a company into business rescue, the moratorium kicks in, and that bargaining position dissipates, and it's gone entirely. We explain this to creditors. So the idea is to explain that there's no point in applying the pressure and to rather work with our professional mediators. And we have a daily training program because of the amount of individuals that are now coming into COBRA, the consultants, to actually deal with specific issues such as how to mediate between debtors and creditors, what type of mediation to use, and the like. So please bear that in mind. I'm going to ask Peter Gordon to give us a brief rundown on business rescue, to give you the general concept, and then we'll go into specifics. And the specifics we refer to as take-homes, where you've got to make a note and you've got to remember it. So over to you, Peter. Thank you very much.
Maurice, thank you for that, and good morning, everyone. Right, business rescue, the legal side of it, it's covered in Chapter 6 of the Companies Act. Essentially, as Maurice said, the big attraction of business rescue, it provides you with a complete moratorium, what we refer to as steel jacket, around the company, which prevents anybody taking legal steps in order to recover monies due to them, or for that matter, any legal steps against the company. What happens, or first of all, how do you go into business rescue? Well, there are two ways. The directors can decide in board meeting by way of a resolution. It requires the majority of directors to vote in favor of rescue. And indeed, the directors have to consider rescue, as Maurice was saying, if the company is financially distressed. That is defined in the Companies Act as the company is unlikely to be able to pay its debts as they fall due within the next 6 months, or within the next 6 months, the company believes, or the directors believe, that the assets of the company fairly valued will be less than the liabilities of the company fairly valued, i.e. technically insolvent. So if either of those two factors are present, the directors have to consider the position and decide whether to go into business rescue or not. Importantly, if they decide not to, in terms of the Act, the company should then give a notice to all what we call affected parties, essentially the creditors, the shareholders, and the employees, stating that the company is financially distressed, the directors have decided not to go into rescue, and the reason why. And Maurice was talking about COBRA, and coming into COBRA would be a valid reason put forward by the company as to why rescue isn't appropriate in particular circumstances. So the directors take a resolution, that resolution together with, importantly, a sworn affidavit. And the important thing with the sworn affidavit from the directors is that it has to state that the directors believe that the company can trade out of its current malaise. That's an important point that the practitioner also has to confirm to the creditors as the business rescue progresses. Having put the company into rescue, and putting it into rescue is merely a matter of filing that resolution together with a form at Sub-C. As soon as that email is sent to the business rescue department at Sub-C, the company's in rescue, and the company then falls under the time constraints laid out in Chapter 6. The other method to go into rescue is by way of a court application. Any affected person, remember, creditors, shareholders, employees, and trade unions, if applicable, can apply to court to put the company into rescue. It's a more laborious process, obviously, because it's coming from outside of the company, but a court can instruct a company to go into business rescue, and the court will then appoint a business rescue practitioner. If we take the director's resolution route, the directors then within 3 days have to appoint a practitioner. The practitioner has to be qualified, has to be licensed. Important point on the practitioners, please, if you are going this route, make sure the practitioner is a business person. There's a lot of practitioners out there who are academically strong, but have never really run a business. And as we know, running a business is about the cut and thrust of business while staying on the right side of the law. As we said earlier, it provides a complete moratorium to creditors. Everything is frozen. On the day of rescue, the amounts owed to creditors, the security in favor of creditors, all frozen. Nothing is cancelled, it's merely frozen. And in terms of Chapter 6, those creditors can only be paid in terms of the business rescue plan itself, which I'll get to in a second. The next important thing with rescue is there must be what we call PCF, or post-commencement finance. Without some funding, in order to keep the company going, it's going to be impossible to rescue. Now, the sources of funding are difficult in South Africa. It's not a mature market. Under the right circumstances, the banks will provide. We normally call on shareholders or anybody that's shown an interest in the company in the past. Importantly, anybody putting money into the company after rescue is then preferred. So that means that they have to be paid whatever they've put into the company before anybody else that was in existence as at the date of rescue can be paid. So it is preferred, and importantly, the practitioner can also give security for the funding now received. And that security is obviously the use of the assets of the company, if not previously encumbered. The directors remain with broadly their full fiduciary duties. Another important point is the practitioner himself or herself picks up full fiduciary duties vis-a-vis the company on the day of appointment. The directors are obligated to generally cooperate with the practitioner, and the practitioner stands in supervisory control of the board. It is often seen as a bit of a negative, because obviously there's a loss of control in the hands of the directors. However, certainly Ian, who's on the panel with me today, and I take a view that we will never go against the directors and we'll never try and run the company on our own. It would be absolutely stupid to do that, because surely the directors have more information and knowledge about the particular industry and the company's affairs than the practitioner does. Staff are classed as affected people. Remember, your staff are creditors at any one day. The fact that an employee has worked for you for a day, a week, 2 weeks, and not being paid means that you owe them money, means that they are creditors. And in addition, there'll be leave pay and bonuses, etc., still payable to them. So they are affected people and creditors. Their contracts, importantly in the Act, are not frozen. So anything affecting the staff, one still has to go through the normal process vis-a-vis the Labour Relations Act. If you're doing a Section 189 staff reduction, the same rules apply. So staff are protected and aren't as impacted as regards their contracts as any other person that contracted with the company prior to rescue. Shareholders have very little say in the rescue unless the plan affects their rights. So if we were to convert ordinary shares to preference shares, for example, or to change the terms and condition of a preference share, then they have to vote on the plan as well, and they have a say in the process. Interestingly enough, customers do not have to be advised that you're in rescue. Morally, one could argue that if you're contracting with a customer and entering into some form of performance contract, one should advise them that you're in rescue. But if one thinks of the retail trade, anybody walking into an Edgar's store in the next 2 months is unaware that Edgar's itself is in rescue, because there has to be no major notice. And if they haven't followed the press, then you might not even know that the retailer is in rescue. Government, SARS, also frozen as at the date of rescue, so no different from other creditors. Interestingly enough, in liquidation, SARS are a preferred creditor, but not in rescue. So they stand alongside the concurrent unsecured creditors of the company. The business rescue plan, I'm not going to go into detail. I'm sure Ian will cover that, but suffice to say there has to be a vote on the plan. It needs the support of the people voting by person or by proxy. And 75% of those that are voting have to say they approve of the plan, of which 50% of the total have to be independent. Independent means somebody that's not currently connected, not a director, not a spouse or a relative of the director, not the business rescue practitioner himself or connected to the business rescue practitioner. So independent creditors must make up 50% of the total vote. The plan gets voted on, it is then implemented, and if all goes well, the plan, the practitioner then takes the company out of rescue, what is termed in the Companies Act as substantially complete. The important thing there is the practitioner doesn't have to complete every last item in the business rescue plan. He can hand that over to the directors to complete. The practitioner is, though, obligated to make sure that the creditors, for whatever deal has been struck with the creditors, is carried through. Normally, there's a compromise in a plan, so creditors will take a haircut. And back to post-commencement finance, the other important thing to remember, of course, is if you're freezing all the creditors of the company on a particular date, that means you're not going to have to pay them in the next, well, until the business rescue plan is implemented. And so you have the free use of that capital that you would have used to pay creditors available to the company as PCF. A rescue can be substantially complete, or we are allowed to, as practitioners, wind the company down in rescues, an organized wind down, because at any one time, the practitioner must state to the creditors that he or she believes that the creditors are going to be better off in rescue than they would be in liquidation. In other words, you've got to surpass a liquidation valuation, not a high threshold to exceed, but the practitioner does have to make that statement to the creditors in every report that he issues. So as I say, the pros: full moratorium gives you the breathing space, and all you have to do is exceed a liquidation value. The cons: losing control to the board, by the board, and obviously the stigma. As Marie said, where we are at the moment with COVID, I think that stigma is fast disappearing, but there is still a bit of a stigma because of how a business rescue first started up and a few disasters in the early days, but I think that stigma is going. Maurice, I think that's it from my side.
Yeah, thank you very much for that. Now, outside of business rescue, I mentioned that that's what COBRA is about. There are other statutory mechanisms that one can employ, and I'm going to ask Ian to deal with the question of Section 155 and a compromise and how that would work. So one does not only have business rescue as an option, you can keep the business out of business rescue and try and arrange a compromise with your creditors. Ian?
Thank you, Maurice, and welcome to all the attendees. Yes, so from the moment we start engaging with a client, a new client, we're permanently, or we're all the time, we're assessing what the best methodology is to apply. And then we've got various choices, and it's very important that we get the right framework in place right from the beginning. So sometimes it's just a case of a business that requires minor intervention with a little bit of our help. Sometimes it's an informal turnaround. We call it an informal turnaround because it takes place outside of the legal framework of business rescue. That we can consider what Section 155 compromise, which is also allowed under Chapter 6 of the Act. Section 155 is the last section under Chapter 6. We've obviously got business rescue, which Peter has explained, and then in the worst case situation, the liquidation. But liquidation is something that it's obviously a last resort. Should always be the last resort. We don't practice as liquidators, and there's no incentive for us to put a company into liquidation. So liquidation should always be considered the last resort. So the Section 155 compromise basically involves a compromise whereby each class of creditors is required to vote on the plan. So a business turnaround professional would put together a plan, and which basically demonstrates how each class of creditor will be compromised or will take a haircut in layman's terms, and in order to reduce the amount owing to them by the company. So as an example, the plan will state that secured creditors will take a 10% haircut, preferential creditors, being SARS and employees, will take a 30% haircut, and concurrent creditors, being the other creditors, will take, say, a 60 or 70% haircut, just as an example. The practitioner then calls together all the creditors, puts the plan in front of them, and each class of creditors is required to pass the plan by a vote of 75% by value of the creditors who elect to exercise their vote in each class. Once the plan has been approved by the creditors, then the practitioner will take the plan to court, and he'll have it made an order of court, and whereafter the company should then be in a solvent position and carry on trading. It is fairly common for us as practitioners to stay involved with the company afterwards to make sure that the operational plan is rolled out properly. One of the advantages of the Section 155 compromise is that it's often cheaper than business rescue, and it can happen a lot quicker than business rescue. One of the disadvantages of the Section 155 compromise is that from the beginning, when you start contracting, when you start dealing with creditors and putting the plan together, the compromise, you don't have the legal protection, steel blanket around the company protecting it from legal attack as you do in the case of business rescue. But, you know, at all times, as I said before, we are monitoring what is the best framework to apply to a company, and the Section 155 compromise is definitely one that turnaround practitioners are using more and more, and which we are certainly using. Thanks, Maurice.
Great, thanks very much, Ian. I just want to check with the audience. We do have Dean, who's a specialist when it comes to the various relief funds. So if you put up your hands if you want us to specifically deal with that. Otherwise, we're just going to be dealing with business rescue in general. But we're more than happy to deal with the latest situation in relation to the funds. I see a hand's been raised already, so we'll be doing with that. Then I had a question by Teresa, which I have responded on the group, and that is whether business rescue applies also to closed corporations. It does. But what I want to mention to you is that despite the fact that it does not apply to sole proprietorships, trusts, business trusts, and partnerships, COBRA will deal with those kind of entities in exactly the same way as any other. It makes no difference. The only difference is that COBRA would not be armed with the ability to put the business into business rescue. But there are a whole lot of other factors in relation to the moratorium, you know, the risk of people suing you. And that's been mitigated by the fact that the courts have been pretty much closed. So there's also, because of the situation, there's just this general inability to actually sue. So there's almost like this natural moratorium that's kicked in. So please bear that in mind, Teresa. If you are a CC, you're covered, hop into COBRA and we'll try and sort you out.
Maurice, just to interrupt this, sorry, just to say one thing. We talked about resolution or court action earlier. Bear in mind that if a application is already before the courts for the company's liquidation, the directors cannot resolve to put the company into a business rescue without sorting out the application first. So it's an important point. So you can't go into business rescue if there's an application before the courts, not a threatened application, but before the courts. And if you then have to sort that out with the applicant before you can go into business rescue. Sorry, Maurice, for interrupting.
No, that's point well made. Thanks for that. Okay, so I want to move on to a take-home that has been mentioned by Peter. He has dealt with it in the opening, but we emphasize it because it's really, really important. And it relates in a way to the moratorium. The moratorium prevents creditors from proceeding with claims. But what about counterparties to contracts? So what about your HP agreements, your credit agreements? What about your lease agreements? Those agreements still run. Okay, so there's the lease still runs, and the company in business rescue's obligations remain despite the fact that the moratorium's there. So what the business rescue practitioner has to do is send a notice to the counterparties, to lease agreements, let's say, to the landlord, saying we're suspending the agreement, and then the landlord cannot place you in breach because the lease has been suspended and cannot do much there. But however, if the business rescue practitioner does not send that notice out in time and the landlord cancels the lease, an eviction is still appropriate. So you can still get evicted if you're not if you go into business rescue and the business rescue practitioner is clueless. So make sure if you're going to be doing business rescue, you're going to be receiving assistance outside of COBRA. Make sure that the business rescue practitioner is aware of that provision and be armed with a list of all the counterparties to agreements, their contact details, so the business rescue practitioner can send those notices out suspending the agreements immediately. So that's essential. Have that list ready. But again, in this environment, everybody seems to be more than reasonable in trying to strike an arrangement, which is great. On the question of agreements, it doesn't apply to all agreements. So you cannot suspend, as an example, an employment agreement. Again, Peter touched on employment law, but I just want to emphasize that the employment relationship remains exactly the same. You cannot suspend the agreement, and you cannot unilaterally say to your staff, I'm cutting your salary by 50%, 25%, or whatever. You cannot vary an employment agreement without a process in terms of Section 189 of the Labour Relations Act. Now, Section 189 of the Labour Relations Act deals with dismissals based on operational requirements, also known as retrenchments. So it's a terrible section to have to invoke because it talks of retrenchments, but all you want to do is you want to hang on to your staff, and you don't want to retrench them, but you want them to agree to a reduced salary. You still have to go through that process because if you make a suggestion or an offer to reduce the salary by, let's say, 50%, and that offer is not acceptable to the employee, then you have to retrench and you have to pay severance. So what you need to do now is obviously look at, and Ian will deal with it later, how to make your expenses, such as even salary, variable, not just slash 25%, because the future is so opaque. How on earth do you know what's going to happen? What if another virus comes along? Sorry, I've lost my chain of thought. So very, very, very key. Staff remain the same. You got to consult, and when it comes to that consultation, it's something again that COBRA can assist on. We can set up Zoom consultations with you first and your team. We can assist in preparing the notices with a view to varying the employment agreements with your staff. Now, the notices, where we say prepare the notices, is very important. You have to prepare a notice in terms of Section 189, dealing with reasons for the proposed dismissals, alternatives that you've considered, etc., etc. So we're quite happy to help you with that. We've had very positive reactions from the staff. We're bona fide. This isn't just a case of a predetermined outcome. The predetermined outcome ought to be saving all jobs on the basis of a variable salary. What we have had in the past is questions in relation to the funding of salaries. We've had benevolent shareholders and directors who've decided to fork out money out of their own pockets with a view to assisting the staff. Now, Peter dealt with the notion of post-commencement finance, and I've asked that he talk to the funding of salaries, okay, as an example. Does one pay the employees direct, or is there something else to this? And this is a take-home, because this is an example of where it's advisable to put the business or the company into business rescue, even though there's no pressure from creditors. So over to you, Peter.
Maurice, yes, thanks. Remember what I said, post-commencement finance is preferred and security can be issued. So with that in mind, there's absolutely no point certainly in the sort of smaller to medium, the SMME market, very much your small restaurants, shops, etc., very much fall into this category, where a shareholder or owner of the business uses personal funds, may even go and take out a second mortgage on their property to invest in the business. Do that before rescue, and go into rescue, you are lumped in with the rest of the creditors and likely to be, like, not 100% certain, but you're likely to only recover part of your loan to the company. Put it in after rescue, you're immediately preferred. Put it in after rescue and ask the practitioner for security, which he's allowed to do. He can secure it over, as I said earlier, any unencumbered assets of the business. Could give you a second mortgage bond over property if the bank currently holds the first mortgage, and you become super preferent. In liquidation, you would be paid out, obviously subject to whoever the first mortgage bondholder, in my example of property, you are guaranteed to be paid out. So it is far better as an owner of a business to put money into the business after it's gone into rescue in order to protect your funds. It's certainly a very secure way of doing it. The other important thing, just not apropos the security, but a lot of people have said to me, and certainly in the early days of the lockdown, not a problem. I've asked my staff to take their annual leave as the fact that they're sitting at home. That's not a clever idea, because whilst people are taking their leave, you're still paying them. The most critical thing at the moment is cash. Assume that you are only going to be up and running in a full form at a date. Could be September, could be December. You decide based on the information that we're getting from the government at the moment. When do you think you're going to be fully up and running with the sort of customer base that you enjoyed in the past, and have a very jaundiced look at the amount of cash that you have in the business or that you have available in the business? And once you've done that, then work out what cash you should be spending. The cash flow forecast has become the most critical management tool at this time. It is very important during any turnaround and rescue, but it's become even more so important at this time. Maurice.
Yeah, thanks. Peter, can you, along the same lines, also deal with the legalities of suretyship? So the question often arises, you put the company into business rescue, but what happens to the sureties? I think there's, it looks like it's Gary. Gary, let me silence you. So just over to you, Peter. Can you please deal with sureties, the legality of sureties, what happens to them? Again, it's one of these important take-homes. It deals with post-commencement finance. Do you pay the surety? Do you pay the creditor directly because you're bound by the surety, or is there another way of doing it? Peter?
Mauricio, there's probably about 5 questions that Ian and I always ask in our first meeting with a company considering rescue, and this is one of them. Have the directors and or shareholders sign personal suretyship? And be very careful for this. You often find that, you know, the new photocopier machine that was on the lease contract, the director had to sign at the bottom of the agreement, and in there is a personal suretyship. So be very careful. You often don't realize. Normally with the banks, it's quite clear that you've issued a guarantee to the bank or issued them with a surety. Remember, it's the company or the CC that's gone into rescue. We're not rescuing the directors or the shareholders. So the suretyship still stands. In the early days of business rescue, a lot of the banks were caught on the wrong foot because the wording of the agreement didn't give them rights to go after the individual person issuing the surety, and had to go via the business rescue process itself before they could establish how much of the principal debt had been settled in the business rescue. The wording of most of those agreements has been changed in so much as business rescue is classed as a default, firstly, and secondly, that the bank has the right to go after either party independent of the other. So the bank can still go after the person that's issued the surety. Now, whilst Ian and I take the view that this is not should not be a concern for the business rescue practitioner, of course, from a practical point, it is. If you're the owner, director of a business, and you've signed over the personal residence as surety, believe me, your attention is going to be very much drawn to how are you going to survive. So we will assist with the banks. We're very close to the, if you like, the business rescue recovery units in all of the major banks. And we will have discussions with them as to how to sort out the security. Now, each case is treated on its own merits. But for example, we recently had one where the shareholder had it was an industrial manufacturing business. The shareholders had lent a fair amount of money. They were the biggest creditor in the company. And their second biggest creditor was their main raw material supplier, who had taken a suretyship off the shareholders. What we did there is there's a compromise, and we got the shareholders to cede their proceeds from their loan repayment to the second biggest creditor, and thereby settle 100% of that creditor. So you've got to be creative. You've got to find ways around this so that you do have everybody on board with you. But the important point is the lender, the bank, the creditor can still go after you personally if you've signed a suretyship.
Excellent. Thank you so much, Peter. I've got a great question again by Teresa. Thanks. Keep these questions coming. So I'll read it out. I have a senior member of staff who's still under probation. In accordance with her contract of employment, I can give her 1 week's notice at this point. I cannot afford to pay her full salary, but I don't want to lose her. If she doesn't accept a reduced salary, is the other option retrenchment or simply notice in accordance with the probation period? if it is retrenchment, what am I obliged to pay her in terms of a retrenchment package? So I'll start on retrenchment. The package is 1 week per completed year. That's the minimum. Or in terms of a policy that you may have, many companies have policies that say 2 weeks per completed year, and then you'd be bound by that policy. But in relation to, you're very different because you've got a probation period in there, and there's a purpose to the probation period, and that is to see whether the relationship works. So you can invoke the probation clause, but I strongly suggest that you still have a very brief, doesn't have to be long, hearing, because substantively let the senior manager make representations. Don't propose a favor. Please say, look, we need to sort this out, and have a brief consultation process. So procedurally, it's fair. You know, labor law is about consulting. Labor law is about trying to reach consensus as opposed to just imposing your will. So yeah, I hope that's answered that. And I'll ask you on labor, Ian. We've dealt with the law, and I've explained how the consultative process works, but I would like to get a perspective from a business rescue practitioner's perspective as to how it actually works on the ground. And I want to mention before we get there, a business rescue that I was involved in, involved a restaurant in Camps Bay. This really illustrates how simple a business rescue can be. The employees were there, and there's the two fixed costs were the staff salaries and the landlord. So obviously you want to negotiate with the landlord first. So what we did is we put the Camps Bay restaurant into business rescue. We went straight to the landlord, showed the landlord what the story was, and the landlord agreed to a reduced rental for the balance of the lease period. We immediately brought the company out of business rescue, published the plan, went through that, and all the jobs were saved, and the landlord had a tenant, albeit at a reduced rental. So, Ian, staff, tell me how you approach them.
Thanks, Marie. So 10 days after the business rescue practitioner is appointed, he's required to hold what we call a Section 148 meeting. So we have a Section 147 meeting where we meet with creditors and we explain to them that we believe there's a reasonable prospect of rescuing the company. Or we provide an opinion as to whether we believe there's a reasonable prospect. As Peter may have mentioned earlier, if at any stage the business rescue practitioner does not believe that there's a reasonable prospect of rescuing the company or giving creditors a better return than in liquidation, then he's required to liquidate the company. The Section 148 meeting generally happens at the same time as the Section 147 meeting, 10 days after appointment of the business rescue practitioner. The practitioner meets with the employees or the employee representatives or the trade union, if that is the case, and he expresses to them whether he believes there's a reasonable prospect of rescuing the company. Typically, the employees would want to know that the company is likely to be returning to a solvent going concern. And returning a company to solvent going concern may mean that there are retrenchments as part of the business rescue plan. So typically at that first meeting, the business rescue practitioner will advise the employees or their representatives whether or not he believes that retrenchment will take place as part of the business rescue plan. So there was an interesting development in the SAA saga where retrenchment notices had been issued prior to the business rescue plan actually being published, and the unions took serious exception to this, and the judge last week actually interdicted the business rescue. He said the process was unfair in that retrenchments had actually commenced before a business rescue plan had been published. Now that adds quite an interesting flavor to business rescues, because retrenchments will often commence prior to business rescue plan having been published. So that's a very interesting one that we are studying, and that as business rescue practitioners we need to take note of going forward. Marie's touched earlier on reductions of salaries as part of the Section 189 process. As he said, we have been doing it successfully. Employees practically are they would much rather take a substantial pay reduction than be dismissed or be retrenched, knowing that once we come out of the crisis, hopefully they will still have a job. So that is something that has been that has been quite successfully implemented by us so far. And that variable, and it's all about creating a variable costing model. And when we talk about a variable cost model, we talk about linking your costs to your turnover. And that has been especially prevalent in the retail sector, in fact, in all sectors. This is a generic rule that we are applying across all sectors, moving from companies that have high fixed cost bases to making those fixed costs variable. You would have noticed when Spur Group came out a few weeks ago and said when they start trading, when they resume trading after lockdown, when they're allowed to start trading again, they will only be able to pay minimal turnover-based rentals. And hence they are making their rentals, which are generally a fixed cost, they are now making it variable. We've been recommending this since the outset, and the same applies to staff. So some companies have been reducing their staff costs down, to say reducing salary costs down to 30% of what they were before. It depends on the nature of the company. It depends how much cash reserve they've got and so on. But let's just say you reduce your staff costs down to, you reduce all your salaries by 70%. In other words, the staff are now receiving 30% of what they were receiving before. As turnover starts coming back, those staff costs can be incrementally increased until they are hopefully at the same level as they were before. There's a more scientific and more technical way of doing it as well, whereby you simply say to your staff, or you work out what they will receive, what total salary can be as a percentage of turnover. You say to them, going forward from this day onwards, from the 1st of June, say, your salary will, the total salary cost will be 20% of turnover, and a portion pro rata across what their employees are currently being paid. And then as turnover increases, the amount paid to salaries increases incrementally as time goes by. So both these, we've implemented both of these models effectively. Staff are very open to it. As I've mentioned before, they would much rather have a job at the end of the day, and they realize that everybody's taking pain. Employers are not earning any turnover whatsoever at the moment in many circumstances, in many cases. Hope that answers your question, Maurice.
It certainly does. Thanks, Jan. We've got another great question, but I'd like to open it up to the panelists, whoever wants to jump in. It's Erwin's question. Erwin's become a regular. I'm always indebted to you, Erwin, for the questions you ask. So the question is, do performance guarantees fall into the same category as a surety? Now, I'm not going to put you on the spot, Erwin, but I'm going to allow you to talk if there's anything that if we have misinterpreted the question, then you can jump in. So I'm activating your mic. It's activated. You don't have to jump in. It's just so long as we understand. So I'll start with Peter. Peter, what are your views on the performance guarantee on this question?
Mauricio, look, a performance guarantee is a classic instrument in construction contracts. And I'm not even going to go down the road of force majeure, because there's enough lawyers on this panel to do it far more justice than me. But generally, if the contractor or the person who's been asked for the performance guarantee cannot perform, one has to ask why they cannot perform. And if it's totally out of their control, then the guarantee cannot be called upon. But obviously, if it is in their control, and one's got to be very careful in these various levels of unlocking down, if I can use that term, to make sure that there's nothing in there that would have allowed the performance in terms of the contract. Because if that is the case, then one can't go down the protection of force majeure. But normally it would be allowed. I'm involved in an EPCM company myself, and what we've done is we've negotiated termination dates on contracts, because that's normally where performance kicks in, and had contracts extended as a result. And because of the current global crisis, we haven't had any resistance to them. So yeah, It's a negotiated situation. But if the performance is just not there, business rescue itself does not prevent the exercise of the performance. However, the issue of the performance guarantee, however, definitely one for negotiation. In business rescue, I'd argue that, all contracts are frozen. So any obligation by the company, and if the performance guarantee has been issued by the company, but remember, if it's not issued by the company, it's going to be backed by classically an insurance company or the bank. And if that were the case, then you might find the client calling upon the issue of the guarantee to pay up. I would argue that either party, the bank or the insurance company, is unlikely to pay up if the company is in business rescue, and they can claim that performance will take time, but it's going to be done under the auspices of the business rescue practitioner. Yeah, that's my view, Maria.
Yeah, that pretty much covers what I would have answered. I mean, if there's an insurance company who honors a performance guarantee, it's because the company doesn't have the money, presumably. So, well, let's just say in that scenario, and if the company raises money by way of a loan account, well, then obviously you put the money into the company, and you'd want to do that as PCF. Am I right there, Peter? Is my line of thinking?
Yeah, I think so, Maurice. Look, I mean, performance could be, it could be a payment guarantee. We take a deposit. We're doing a contract. We take a deposit. We have to issue a guarantee for that deposit. But it's as long as it's the company that's issuing whatever the security is, then that's frozen. It cannot be challenged. If another party, a third party, has issued it, then clearly they're going to go through the route of could performance be completed. And I would argue that the mere fact of going in, remember, business rescue is, in inverted commas, business as usual. Obviously, it's not usual in so much as it is in rescue. But other than that, we try and trade the business exactly as it would have been traded under normal conditions, and identifying fairly rapidly what the problems were so that we can get rid of those problems. It might be a division. It might be a subsidiary that's drawing cash. We might liquidate a subsidiary within a group. If it's a big cash drain, and thereby create a leaner, meaner business to hand back to the creditors, or indeed sell on to other shareholders if that's in part of the plan, and from the proceeds pay out the creditors. So we're trying to complete contracts. If it's a construction business, you're trying to complete those contracts, because the contract, remember, from a construction contract point of view, albeit it's frozen, doesn't mean that you can walk away from it. You still have to perform under the contract, but you're now performing in terms of business rescue. All that it means is nobody can take legal action against the company for non-performance under that contract whilst in business rescue.
Excellent. Thank you. Thanks so much. I'm going to jump into the funds now, and I'll ask Dean to take us through the latest there. The funds, and I mean, this is really a moving target. It changes literally on a daily basis, and the funds are added. Dean, where are we?
Yeah, morning everyone, and morning to the attendees. So I think I'm looking at the time permitting. I just wanted to highlight a couple of things. Is because it's a moving target, we have a whole complement of people behind the scenes preparing firstly a very up-to-date website, and I urge all the attendees to go to cobra.org.za is the COBRA website. And if you scroll down to the bottom of that website, you'll see we've changed it very, very recently. And as I said, it's ever changing. But there's a link there that says Help Portal and Knowledge Base. What this will take you to is the various initiatives that are available to various sections of South Africa and for foreign companies. And just as a highlight, the main ones are the bank initiatives, the government initiatives, there's solidarity initiatives, business initiatives, and insurance initiatives, and telecoms. So what we've worked hard at is preparing snapshots of the various available initiatives under each of those headings. At this stage, I think there's about 40 or so. And each one has their own requirements, so it's quite hard to discuss each of them in detail. What I'd prefer to do is, if you need further information, please prepare an email to us, send it to info@cobra.org.za, and we'll be able to help you with that. But I think what we're finding are the top 3 ones that we have been asked about, and we'll get to TERS being the most one lastly, but there's the COVID-19 loan scheme, which we've heard quite a lot about, and the debt relief fund, which we've heard a lot about, as well as the growth resilience facility. I'd suggest that all the attendees who are looking for that some type of funding go and start at those ones and then obviously filter down. But in saying that, we are finding the most engagement between these companies, SMEs looking for funding, has been with their bank. A lot of people aren't going to their banks as a first port of call, and the bank initiatives are, I think, one of the first ones that every attendee should have a look at, and engage with your bank at that level to find out if there is some loan funding available, if they could ask for payment holidays on certain debt relief. And you'll see a lot of the initiatives, other than the bank ones, are facilitating these loans through banking institutions. So because they are in a position to put in the necessary security in place, such as surety ships, if it's for SMEs, relating to the directors or shareholders, depending on how the structure is. And that's why I think most people should, SMEs particularly, start at the bank initiatives, then look at the 3 ones that I've mentioned. As I said, one of the questions we get most of is help with the TERS, which is a government initiative through UIF. And this one in particular is quite interesting, because there's been a lot of success stories, and then there's been a lot of querying of that for whatever reason they had been rejected. And we are aware that there has been some technical difficulties, and some of them haven't gone, some of them haven't been accepted purely on a technicality. So what we're urging attendees to do is just carry on trying. And if it still doesn't come right, we're more than happy to assist. If you can just tell us why it's been rejected, that's very important. And I think the umbrella aspect of all these initiatives, which is important to note, is that a lot of them look at your corporate governance. And this is a very important point, and particularly for the tax incentives, as well as these UIF. For example, the TERS UIF is for TERS, you have to have been UIF registered prior to COVID. You have to be up to date, but there are some concessions that they will make for SMEs, and that would be to sign acknowledgements of debt for outstanding UIF payments, to bring it up to line and allow employers to make application on behalf of their employees. So that's quite a nice development that we've seen. But more than likely, and specifically with the tax initiatives, your company or SME has to be tax compliant. You have to be up to date. Your corporate governance has to be in check. And it's only these companies that we're seeing are getting assisted first. So in order to properly make use of these initiatives, we urge everyone to make sure that their corporate governance is up to date, they have their tax compliance up to date, they've made sure their UIF is up to date, and they are in fact registered for UIF. And then it seems that these initiatives are very successful. That's really in a nutshell, Maurice. And just as a side note, I've seen that not only do we have like a plethora of the information on the incentives, we also have various articles that we Schindler's attorneys have prepared that are on that knowledge base and knowledge portal as well. And there are hundreds of articles that are linked to our Schindler's website, and the most prevalent ones we've put onto the COBRA website, dealing with all types of questions surrounding COVID and the effects. There's ones about property, there's ones about community schemes living, there's as I said, there's plenty. That any question that I think the audience would have, it's probably going to be answered there. And the nice thing about it is that we've developed it in such a way that on the website, if you scroll down to the bottom right, there's a green button that says request assistance. And this works very much like a Google search bot, if you will. As soon as you start typing it, it's intuitive. It'll be able to find the articles relevant, the fund initiative relevant, and it saved everyone a lot of time than searching hundreds and hundreds of pages for the same information.
And I think we were told yesterday that, in fact, the knowledge base, and this is from various industry leaders, is in fact the best available knowledge base in the country. So well done to IQ Business for putting that together. It's absolutely epic. I mean, a lot of work has gone into it. So I'm gonna wrap up on the questions. If you can please put in your final questions now, so we can conclude with their answers. I just want to mention that the Schindler's Insurance Department, Insurance Litigation Department, has actually received quite an uptick on repudiations on business interruption insurance. And these repudiations have been tenuous at best. I mean, I'll give you an example. One insurance company has adopted the view that they're not paying out because the loss was not caused by an infectious disease, but rather by the shutdown. So the issues like that are arising on the insurance front. So if you have insurance policies, if you are covered and you want your policy analyzed, if you want your views, our views provided, please do not hesitate to reach out to us. We'll address that. So do we have any questions? Here's another great one. Can I use a force majeure clause in my contract lease agreement to terminate my contracts with suppliers? So when it comes to force majeure, there are two positions. One is the contractual position. The other one is our common law position, i.e. what would the position be if there's no contract? And what one must do is one must look, you're mentioning contract here, so I'll deal with contract. You look at the clause and you see what the clause says around cancellation. So the first thing to do is to see whether the force majeure would kick in. There have been many debates such as, does it kick in if you can't get to your offices? But those offices are still storing the furniture. So what then? I mean, if you're still storing the furniture, you're still making use of the premises. So is it a true force majeure because you're still making use of the premises? Performance has not been interrupted. So on that, again, send us your contract and we'll give you our views within 24 hours. That's the point of COBRA, is that you do engage us, and then we can follow up with a Zoom and we can look at it and we can look at the various options that you have. But on the insurance, it looks like what we're going to be having is quite a few business plans. And I know I'm going to conclude with your views here, Ian. Do you foresee, this litigation, business rescue plans merely being the pursuit of an insurance claim?
Yes, absolutely, Maurice. And we've had business rescues in the past that have merely been the success of the business rescue plan has merely been the collection of an insurance policy. In fact, it was a business interruption policy that we dealt with a couple of years ago, whereby a large factory had burnt down, and the payout was quite substantial. It was a very substantial amount of money that was envisaged, and the directors of the company kept telling creditors they couldn't pay the creditors, and they kept telling creditors that the insurance company was paying out, and but the creditors weren't believing them, and eventually the creditors were starting to threaten liquidation, and we found it necessary. The directors approached us to put it into business rescue, and we placed the company into business rescue. And before we even had the business rescue plan published, the insurance company had paid out, and all creditors were settled. So yes, I mean that was a nice example. It was a very nice business rescue. I mean, it was settled very quickly. But the entire plan, the business rescue plan, can revolve around litigating with the insurance company who's refusing to pay for whatever reason, and in order to make sure that we get paid, or that we achieve some sort of settlement with the insurance company. And I believe, from what I've heard, there have been some settlements with insurance companies that have been negotiated as a result of litigation or threats of litigation by business rescue practitioners. So yes, the entire business rescue plan can revolve around negotiating a settlement with an insurance company. In this case, in the case of COVID-19, the payout, the payout of an insurance claim for business interruption is often the difference between complete disaster, or a really serious problem for the company, or not having to worry about anything really, because the insurance claim basically pays out their gross profit in a typical scenario, and then it's left to the company to settle their operating expenses. And should the company receive its gross profit for the next 6 months, you can imagine it'll hardly have any problems. It'll be in a better situation than everybody else out there.
Yeah, but now it begs the question: it's the journey. How does one sue? How does one go to the higher court? You need to engage attorneys. They're going to require a massive deposit for litigation. They're going to want to engage advocates, etc., etc. And that's why we set up COBRA, because we can provide all those services, okay, and not cripple you financially. Do them on a pro bono basis if they're going to become the difference between a successful business rescue and a liquidation. And if we do not come right with rescuing your business, if you come to COBRA now and we don't come right and there's an inevitable liquidation, that's another high court application. And that's another cost of between 30 to 50,000 rands, which will be absorbed by COBRA. So to conclude, I'd like to thank my panelists. I'd like to just mention a few webinars that are coming up. Tomorrow, we'll be doing a webinar on how property has been affected by COVID-19. On Thursday, the webinar is specific on retrenchments, ensuring that employers act fairly. That's quite interesting in light of the questions that arose today. And then on Friday, we have a webinar on tax at 10 o'clock. And then a weekly economic wrap-up with Safiso from IQ Business. He's an economist, and he'll reflect on the week and give us his views on where we are. So thank you once again. I hope to see you tomorrow. Thanks to the panelists. Goodbye.
Thank you.